couple's divorce, there are a number of important issues that you'll need to consider, including what your financial future may look like. This can be quite daunting at the beginning and rather unsettling. This is where Family Law Group can help. The first step is to ascertain what is included within the matrimonial finances. The starting point is that all of your joint finances, as well as your own individual and your spouse's individual finances, should be thought of as part of the marriage. These will include all your capital, such as a family home, any savings, any investments. It will also include your respective incomes and your respective pensions. Your solicitor will need as much detail as possible at the outset of your case in order to provide you with guidance and advice as to possible outcomes. The starting point for the division of matrimonial assets, this being your capital and pensions, is an equal division between you and your spouse. However, there are a number of factors that need to be taken into consideration, which can, in some circumstances, lead to a departure from this equal division. Your solicitor will take these fully into account alongside the context of your overall assets to advise you fully in respect of your specific circumstances. Whether you have children and what provision is needed for them will always be the first consideration. Other factors that may be relevant in your specific case are the length of your marriage, your respective ages, and your respective earning capacities. Your solicitor will also need to consider your income position and whether it is whether you need regular payments or indeed need to make regular payments to your spouse. The next step is to consider the most appropriate way forward for your case. It is important that divorce proceedings are started at the very earliest opportunity. Any financial agreement that is reached between you and your spouse can't be made legally binding until an order is sealed by the family court. The court can't do this until decree nisi of divorce has been pronounced. There are three main ways to resolve financial issues. Firstly, mediation may be appropriate in your circumstances. Alternatively, you can consider negotiation through solicitors. This can include a roundtable meeting between you, your solicitor, your spouse and their solicitor. Such a route is a good way to avoid the costs and length of court proceedings. Thirdly, if negotiations break down and mediation is unsuccessful, then it may be necessary to issue an application at the family court for financial proceedings. Your solicitor will advise you throughout these proceedings as to any appropriate proposals for settlement. However, if agreement can't be reached, then a judge will decide how your matrimonial finances should be divided. Whatever route you take, you and your spouse will need to fully disclose your finances to each other. This will either be through voluntary financial disclosure or the Form E in court proceedings. All of your financial documents need to be disclosed and shared, including wage slips and P60 to show your income, valuations for any property, mortgage statements, bank statements, and formal valuations for your pension called cash equivalent transfer values. It is only once this disclosure process is completed that your solicitor will be able to fully advise you in respect of a final settlement or agreement. This will be based on what is considered fair and reasonable in taking into account all the circumstances of your specific case. Whatever route you take, the Family Law Group can help support you through it. As well as our mediation service, we have a large team of experienced divorce and matrimonial finance lawyers who are trained to negotiate and reach the appropriate settlement for you, whether this be through negotiations with your spouse's solicitor or through the court process. We will also assess each individual case on its own merits and offer fixed fees for our services where appropriate.